to the Civil Asset Forfeiture Act. I'll start just by highlighting the recommendations of the 2023 Special Committee on Civil Asset Forfeiture. They recommended 8 measures, and all 8 of these measures are in the bill. So as I go through these, you'll hear about them again later. 1, deleting offenses involving controlled substances that apply primarily to a quote-unquote user from the list of offenses giving rise to forfeiture. 2, requiring seizing agencies to return property if certain timelines are not met, to engage an attorney or otherwise move the case forward. 3, prohibiting pre-forfeiture waivers of rights and property. 4, allowing a proportionality hearing to be requested at any time. 5, requiring a judge to determine whether there is probable cause supporting forfeiture as a preliminary matter. 6, requiring an automatic stay of discovery in the forfeiture proceeding during a criminal proceeding alleging the same conduct. 7, establishing that a seizing agency can be ordered to pay a prevailing claimant's attorney's fees. And 8, requiring the state to prove property is subject to forfeiture by a clear and convincing standard rather than a preponderance of the evidence standard. In addition, the committee recommended the following items be further studied by a standing committee of the 2024 legislature. 1, transfers and federal adoptions. 2, the right to jury trial in forfeiture proceedings. 3, the right to counsel in forfeiture proceedings. And 4, where forfeiture proceeds should be directed. And I note that the bill contains provisions related to federal adoptions and jury trials. So 2 of those additional items are in this bill and 2 of them are not. Moving then to the substance of the bill, and as I mentioned, you've got a fairly substantial bill brief, but I'll try to hit the highlights for you. I know a few of you are on the interim committee and you have this background, but the rest of you may not have as much background on forfeiture, and it gets fairly dense fairly quickly, so I'll try to keep it brief. Section 1 is amending KSA 60-4104. That is the statute in the Forfeiture Act that defines what conduct and offenses give rise to forfeiture. So under current law in subsection B, the entire Controlled Substances Act is included. It's KSA 215701 through 215717. The bill would amend that subsection to include only violations involving controlled substances that are specified there. The result of that is that it essentially excludes possession, what we'd call simple possession around the building, and other crimes that are associated only with personal use of controlled substances. So essentially it carves out possession of paraphernalia, and some other similar crimes. Those are no longer going to be subject to forfeiture under the bill. Section 2 then gets into KSA 60-4106. This is the statute dealing with what property is exempt from forfeiture. I note that current law has some provisions about in a forfeiture proceeding prior to final judgment, the court limits the scope of a proposed forfeiture to the extent the court finds that the effect of the forfeiture is grossly disproportionate to the nature and severity of the owner's conduct. And in the bill, that provision is amended and essentially kind of moved to a different location. And so here in its place, the court is required to determine whether the proposed forfeiture is unconstitutionally excessive pursuant to KSA 60-4112 subsection G, which we'll talk about just a moment in section 6. And they only do that if the court has not already made that determination earlier in the proceeding. So 60-4112G provides that opportunity earlier. If it hasn't been done, this statute requires the court to do it before the proceeding is concluded. So that's the unconstitutionally excessive finding that was mentioned in the interim report. Section 3 then gets into KSA 60-4107 related to seizure of property for forfeiture. This is the section that kind of defines the timeline for the initial steps in the process. The agency has 45 days to forward a written request for forfeiture to the county or district attorney where the seizure occurred. That's current law and that remains. Except the bill reduces that to 14 days. So it's a shorter time frame to get the request to the county or district attorney. And then there's additional timelines provided by the bill related to 14 days after that decision is made or after that time expires. And then ultimately the agency has to engage an attorney to represent the agency and to get the action going, or they have to return the property that was seized. So all of that is provided there in section 3. And again, that's one of the interim recommendations. Also in section 3, there's a current subsection that allows a seizing agency to request federal adoption of a seizure to provide, and the amendment provides that no law enforcement agency will be able to do that anymore. The agencies will not be able to request federal adoption of a seizure pursuant to this act. So that's one of the additional considerations from the interim report. And the first instance of that is there in section 3. Finally, there's a new subsection P that's added to section 3 that provides a seizing agency shall not request, induce, or otherwise coerce a person to waive their rights involving certain property, and that's one of the specific recommendations from the interim committee. It's found there near the end of section 3. Moving then to section 4, this is KSA 60-4109 related to commencement of forfeiture proceedings. The amendments there provide that an affidavit describing the probable cause supporting forfeiture has to be filed. And after that affidavit is filed, no further proceeding shall occur until a judge of the district court has determined from that affidavit that there is probable cause to believe the property is subject to forfeiture. So this is in the interim committee talking about the probable cause affidavit and the initial probable cause finding. It's found here in section 4. Section 5 then gets into KSA 60-4111 related to claims under the Forfeiture Act. The bill adds a new subsection here that requires the plaintiff's attorney to file a notice of receipt with the court when a claim is received, unless it's already been filed with the court, essentially putting the court on notice that a claim has occurred, and that facilitates some of the other provisions of the bill. So I wanted to highlight that real quick. Section 6 gets into KSA 60-4112 relating to judicial proceedings under the Forfeiture Act. The amendment in subsection C provides that at any time prior to final judgment, an owner or interest holder may petition the court for determination or reconsideration of its prior determination that there's probable cause to believe that the property is subject to forfeiture. So the amendment here says you can make that request at any time, even ask for reconsideration related to that probable cause finding we discussed above. The bill also amends subsection E to provide that if there is no probable cause finding, the court orders the property released to the applicant as a custodian for the court or releases it from the lien subject to the outcome of the judicial proceeding. So there's a secondary piece to that as well. Also in section 6, this is the provision I mentioned earlier about proportionality hearings, and it also provides a non-exclusive list of factors for the court to consider in determining whether a forfeiture is unconstitutionally excessive. So if you're looking for that particular item or that list, it's found there in section 6 in a new subsection G. Finally, in this section, a lot going on in this one, obviously, subsection O is the provision that requires the court to automatically stay discovery against a criminal defendant and against the seizing agency if the civil proceeding is related to a criminal proceeding alleging the same conduct. So the current law is that a motion is required to make that occur, but this would be automatic. That's in the end of section 6. Section 7 then gets into KSA 60-4113. This is the in rem forfeiture proceedings. The main thing here is the new provision in subsection C that allows a claimant to demand a jury trial pursuant to our Code of Civil Procedure, KSA 60-238. That is one of the additional recommendations that the interim committee recommended a committee of the legislature consider, and it's found one instance of it there in section 7. In addition, this section amends subsection H to provide that the plaintiff's attorney has the initial burden of proving the interest in the property is subject to forfeiture by clear and convincing evidence rather than by a preponderance of the evidence. This is one example of that increased burden of proof. It's found there in section 7, subsection H. Section 8 amends KSA 60-4114 about in personam forfeiture proceedings. There's a new provision in subsection F that again allows a claimant to demand a jury trial pursuant to the Code of Civil Procedure. So that's the other change related to that topic. Section 9 gets into KSA 60-4116. That is about judicial disposition of property. I kind of mentioned in the memo that the current law in subsection F requires the court to order claimants who fail to establish that their claim is exempt from forfeiture is required to pay other claimants' expenses. The bill changes that to a permissive order, so a shall to a may. So that's one change in this statute. But to the committee's interim recommendation, the more important change there is the new language in the bill that adds a court is required to order the seizing agency to pay reasonable attorney fees and costs to a claimant in any proceeding in which the court finds that the claimant has prevailed by ordering the return of at least half of the aggregate value of the claimant's interest in property or currency that they inserted an interest. So if you assert a claim, you prevail to the greater degree of 50% of whatever your claim was, the seizing agency would have to pay your attorney's fees. And that's a new provision and it was one of the recommendations of the interim committee. The last thing I'll note here is that there is a subsection that provides the seizing agency is not liable for attorney fees and costs under certain circumstances. So there are some exceptions to what I just said, and I wanted to make clear that that's in subsection G of that section. Section 10 then gets into KSA 60-4117 about disposition of forfeited property. And as I mentioned, many of you know this from past experience, but just for those who might not remember, there are two current pieces in this statute of current law that require each law enforcement agency that does forfeitures to deposit their proceeds from those forfeitures into specific funds that are not a source of revenue to meet normal operating expenses and are only allowed to be expended through their normal appropriation process for special additional law enforcement purposes that are specified in this section. So the amendment to the section doesn't change any of that. It just adds one new additional thing that those monies can be spent for, and that is to pay for the attorney fees that might be awarded under the section we just talked about. So no real change to any of the rules about these fees or these funds, just that it can be used to pay for those attorney fees we just talked about. And the last section is section 11. This is related to the repository in KSA 60-4127. The legislature enacted this repository just a few years ago. And currently, every agency reports information about each seizure, and then they're also required to file a financial report by February 1st of each year. Current law also requires the KBI to tell the legislature if any agency is not in compliance with that financial report. So what this bill would do is require that report to go to more folks in the legislature, so the president, the speaker, and both standing committees on judiciary. So you would receive it as well. You would get the report of any agency that has failed to comply with the reporting requirements, but you would also get each agency's forfeiture fund financial report. So all of those reports that come in about the money would also be given to the legislature if you enact this bill. And I'll mention that it would become effective on July 1st, publication in the statute book. And I think that's probably more time than I wanted to take. So I appreciate the committee's indulgence, and hopefully we can get along with it.
Thank you. Committee questions for the revisor. Senator Olson.
Yeah, Jason, is there any online recording provision like at the Attorney General's office or somewhere? I think, that would be good too if we had a place to show each county and how much they've, taken of forfeit money and where it's going.
Madam Chair and Senator Olson, yes, in the legislature's wisdom back in 2018, by July 1st of 2019, the KBI was required to establish and maintain an associated public website with the repository. That provision is on page 25 of the bill, kind of in the middle of the page. It's current law. It's not changed. So that website is up and running. It has a host of reports and information and data that you can access now and will continue to be able to access.
Thank you, Jason.
Thank you. If you could describe for just a minute the jury trial in section 7 and section 8 and explain for the audience the difference between an in rem proceeding and an in personam proceeding. And because the bill proposes a claimant may demand a jury trial for an in rem proceeding in section 7. And then I think for an in personam proceeding in section 8. So if you could just clarify the difference. Thank you.
Sure. Thank you, Madam Chair. So generally speaking, NREM means it's filed against the property, not a person, and in personam, it's filed against a person. So that's just the real broad brush of those two legal concepts. And because the Forfeiture Act separates those two proceedings and has slightly different mechanics, I guess is the word for it, I needed to put that provision in both statutes so that either way it was filed, a claimant would have the right to request the jury trial, and that obviously changes the rest of the proceeding depending on which one you're in. That makes some effects. But essentially, you would demand the jury trial in the same way that you do under the Code of Civil Procedure. So the party serves the other parties with a written demand and specifies what issues they want to have tried before a jury and what issues they may not want to have tried before a jury, and the court would proceed just like they do in any other civil matter.
So if it's your cash or your car or your house that's been seized, could you answer which of those would be an in rem proceeding and which of those would be an in personam?
Thank you, Madam Chair. Honestly, I think it depends on how the agency files it, or how the attorney representing the agency files it. I think if you can identify the person, you file it in personam, if I'm not mistaken. But if you have cash with no asserted owner, it wasn't mine, right? The classic case, it's not my cash. That's an in rem proceeding. You don't have a claimant yet. You don't have anybody to name in the case. And you've got some experts behind me that can clarify anything I misspoke on. I have just enough knowledge about these proceedings to be dangerous. So take what I said to that effect. But essentially, either way you get into the proceeding, once you have a claimant who's asserting an interest in that property, that's the person that would have the right to jury trial. So kind of however you get into the system, whenever someone steps in and says, that's my money or that's my property, they may have been identified already, they may not, but then these procedures would apply to that person. Hopefully that
Thank you.
helps.
Thank you. Committee, other questions? Not seeing any. Thank you. Committee, we do have limited time today and a number of in-person, not in personam, but in-person conferees today who wish to testify. So we're going to ask our conferees each to limit your testimony to 3 minutes. And I will have a timer that when the timer goes off, if you'll be kind enough to stop your testimony, that would be appreciated and enforced. And with that, then we will have our first proponent conferee, Senator Oletha Faust Godot. I don't have which district, but please introduce yourself, Senator, and welcome to committee.
Yes. Oh, there we go. Um, Good morning, State Senator Oletha Faust-Godot, 29th District, Wichita. Madam Chair Warren, Vice Chair Wilborn, and Ranking Member Corson, and the other esteemed members of the committee. Thank you for the opportunity to speak in support of Senate Bill 458. Madam Chair, some have said that they couldn't believe that I was testifying along with Americans for Prosperity. Madam Chair, um, however, if legislation is good and it's going to help our constituents throughout the state of Kansas, regardless of the party difference, uh, you need to support that legislation. Madam Chair, also, I am here testifying in support of this legislation because of our late colleague, Representative Gail Finney. She worked on this issue for many, many, many years. Madam Chair, I am so glad that you mentioned the cash piece. One of the things that Representative Galfini and I, who represented the same area in Wichita, years ago, there was a lot of our constituents that worked at Coleman, and they worked that late shift. And a lot of them would get off of work, and there was a convenience shop nearby that would cash their payroll checks. And then sometimes they felt that they were stopped a pretext stop, and that even though they had a paycheck stub to prove I just cashed my check, this is my money, if they had additional money with them, it was combined. And if it didn't total up to that amount, that money was seized. And so some got their property back, some didn't. I know that Representative Gail Finney was really advocating for it not to take so long to get your property back, and the process be less burden on that individual to prove. And I think this legislation, from what Jason described, kind of addresses the issue up front with that clear and convincing evidence before seizing one's property. And so, Madam Chair, I stand in strong support of Senate Bill 458. And I'll stand for questions at the appropriate time, Madam Chair. I do have another committee to testify in this morning. And so I appreciate your indulgence. And I would hope that the committee would pass Senate Bill 458 out favorably. Thank you, Madam Chair.
Thank you, Senator. And because you have other committees to get to, we'll take any questions for the senator right now before she leaves for other committee work? But seeing none, then thank you very much, Senator. Appreciate it. With that, then, we will hear from our next proponent conferee, Sam McRoberts, Litigation Director, Kansas Justice Institute. Please introduce yourself and welcome to committee.
Good morning. I am Sam McRoberts, and I am the Litigation Director at Kansas Justice Institute. I sat on the advisory committee over the summer. And so as a committee, we studied asset forfeiture. We had robust conversations with law enforcement. We had robust debate with all of the stakeholders in Kansas. And I think if there was one thing that all of us agreed upon, and of course they'll correct me if I'm wrong, is that the number of defaults in Kansas are extraordinarily high. What that means is people who've had their property seized by the government give up. And according to the last version of the report that I saw, around 70% of Kansans just give up trying to fight the forfeiture case. 70%. That's an incredibly high number. Now, where perhaps law enforcement and others might disagree is, why do we have these defaults? Our position is the reason these defaults exist is because it's incredibly hard to navigate this system, especially for people who don't have lawyers. Even for lawyers who sit down and try to read the forfeiture laws from start to finish, have a difficult time understanding how these procedures work. It's complex. There are a lot of procedural hurdles for individuals who don't have attorneys, meaning if you make a mistake and you don't file a response to the government's paperwork, you default. You lose your case. You don't have the chance to get your car back. You don't have the chance to get your money back. For some, it's incredibly daunting to have to prove your own innocence. And for a lot of people, they feel like it's not a fair fight. And that's because under the current asset forfeiture regime, it's incredibly easy for the government to prove their case. The standard of proof is so low that it's easy for the government to actually win. I think at its core, our position is it's too easy for the government to take your property. And so that's why this bill represents a very good opportunity to level the playing field. Our position is the playing field should actually be against the government. If they're going to come in and try to take your property, it should be tilted against the government. But at the very least, this bill creates an opportunity to make it an even playing field. And I say that because now there's going to be a probable cause requirement, so law enforcement has to sign a probable cause affidavit. I credit Director Mativi for coming up with that idea. It was a fantastic idea. It's one that should be included in this bill. The second thing that the committee came up with, which I would urge this committee to continue considering and adopt, is the attorney's fees provision. Now, the way the law is currently written, if the government wanted to, they can seek attorney's fees from the person who had their car taken from them. But there's no opportunity for that person to get attorney's fees from the government. This current bill, this
I'm
draft,
sorry, that's 3 minutes, and we do have other conferees to get to, and we will reserve questions then till we've heard from all the proponents. But thank you, Mr. McRoberts, appreciate it. Next, we'll hear from Greg Glod, Fellow, Public Safety and Criminal Justice. That's not the entire title, but he can introduce himself, please, and welcome to committee.
Thank you, Madam Chair. Can you all hear me okay?
Yes.
Okay, great. Hi, I am Greg Glod. I am the Public Safety and Criminal Justice Fellow here at America's Prosperity. I apologize I couldn't be there in person. Flight got canceled, and here we are. So I'll be short. I know we have abbreviated time here. I was able to testify during the interim committee hearing back in December, and my written testimony, I have adopted that in there. And so I can generally just go over a couple of the little things that I wanted to touch on specifically for this bill that I think are very important. And Sam just mentioned a few. First, on the adoptive forfeiture aspect, I think the language is solid, and this is a way that we've seen other states when they've passed adoptions. I mean, they've passed civil asset forfeiture reforms. Adoptions become kind of this almost loophole to get around these types of things. And so, you know, a great example from the Inspector General, the U.S. Inspector General did a report and actually interviewed a lot of officers across the country. And North Carolina and Nebraska, which have some of the strongest forfeiture reforms in the country, they actually, a lot of law enforcement there said they increased their adoption specifically so they could get around the new laws. And so this is why removing these or, you know, potentially, really restricting them is incredibly important. And really one of the major issues, particularly with adoptions, is that they're an old adage of the past. They were created as a policy when states did not have a lot of civil asset forfeiture laws. Now that every state has them, these are really unnecessary and deprive Kansans of the actual laws that you all are trying to pass and brings it to the feds. And I can go over horror story after horror story and provide some more information on that in a little bit. I also wanted to mention on the jury trial, because I'm sure that there's going to be, potential critiques of having that where, hey, we're going to have juries and costs and all these things. One, having a jury trial when we're going to deprive someone of life or liberty and property, I think is incredibly important. I put all those three together. I don't think one should have a different, process than the other. Those are all incredibly critical pillars of who we are as a society. And I wanted to mention the Supreme Court in Indiana just recently ruled in October that constitutionally Indianans have a right to a trial by jury for forfeiture cases. And it looks like if this goes to the Supreme Court, that's a way that they're going to vote as well. Justice Thomas, as conservative can get, has, lambasted the practice of civil forfeiture and has said that this is something that he really wants to look at. And I think these constitutional protections are incredibly important in the meantime. Additionally, on attorney's fees, we just talked about how limited a lot of these forfeitures are, and the low thousands. And having attorney's fees as some skin in the game here, I think is incredibly critical to ensure that people have those constitutional rights where they're not going to be limited by red tape and bureaucracy and cost. And it also makes law enforcement and government officials, wary and be really, sure that what you're doing right now is important. So it allows for these types of reforms to actually kind of have those things. It brings those incentives kind of right-sided, in my opinion. So I really want to touch on those three aspects. I'm sure we're almost here at time. Those are the three I really wanted to touch on for this bill. We are strongly in favor of this. We have looked at this bill and advocated for.
That's 3
Thank you,
minutes,
Chairman.
Mr. Glad.
Yes.
Thank
Happy
you.
to answer your
Appreciate
questions.
it.
Thank you.
Thank you. And committee, then we will open it up for questions if there are no other proponent conferees. Not seeing any. Any questions? Senator Gossage.
Thank you, Madam Chair. I guess this would be for any of the proponents to come forward. What is it in the bill that you think will help the problems that you stated?
Welcome back to the podium, and please introduce yourself.
Sam McRoberts from Kansas Justice Institute. There are a number of things in the bill that would help, in our view, decrease this default problem. One, I think perhaps one of the most important ones is the changing of the burden of proof. That would, in our estimation, require the government to more carefully look at all the forfeiture cases to make sure that what they're filing and what they're seizing, that they could actually meet that burden of proof. I think another one is the attorney's fees provision, because again, as Greg just mentioned, that requires the government to have a little bit of skin in the game, so to speak. And so if it were a close call on a case, if maybe the government thought, well, it's a 50-50 case, let's just go for it in the olden days. Now they might say, well, this is a 50-50 case, let's not do it because we don't want to get hit with attorney's fees. I think the jury trial provision is incredibly important because I think that it would cause the government to think about whether or not they could prove that case to a jury of that person's peers. And so for some jurisdictions, I think it would be difficult for the government to prove their case in front of a jury. Those are kind of, I think, the highlights of the bill. And also, I mentioned this before, but the probable cause affidavit requirement, I think, is significant. Again, credit to Director Mativi for that. The reason I think that's important is because before you were getting forfeiture pleadings where an attorney would just say all the facts that form the basis for this forfeiture are in a police report. Well, then no one actually sees the police report. The judge doesn't see it. The public doesn't get to see it. And now law enforcement is going to have to swear under oath the facts of that case. So I think those are really the highlights.
One more question. Thank you.
Oh, if I may add to that, if that's all right, Madam Chair.
Sure, please introduce yourself.
Greg Glod with Americans Prosperity. I just want to give an example of a case I think really shows the importance of not only limiting or restricting equitable sharing, the adoption program that this would remove in this bill, and the attorney's fees. A case out of Arlington, actually, in 2015. A woman, while she was at work, police raided her home and seized her entire life savings that she was saving for her child, her daughter, $15,000, on a tip that her estranged husband was dealing drugs. He wasn't, but the DEA still filed a forfeiture on that, which we could be allowed to do with the adoption program if it started as a Kansas case and then moved into adoptions. She hadn't done anything wrong. The case was dismissed, but the federal government refused to pay her attorney's fees. And so not only did they essentially illegally take her money based upon faulty evidence and just a tip, she actually had to pay her attorney $5,000 for the trouble of getting that taken away. And now the Institute for Justice is actually suing on this case, and there may be actually some some court cases coming down the road that are actually going to solve this issue, as well as the other aspects of adoptive forfeitures and a few other aspects. So just want to mention that case, why it's so critical to protect Kansans, I think, from the federal government in these ways, and why having attorney's fees will protect a lot of these constitutional rights that we want to uphold with these changes in this bill. Thank you.
Thank you. Go ahead, Senator Gossage, and then Senator Olson, and then Senator Haley.
So if I could have, and I'm sorry, I've forgotten the name of the gentleman that just spoke, Greg Glod.
Yes.
So I'm trying to make sure I understand. Somebody is stopped for a broken taillight or something, what else? And can they search their car to say, oh, you have cash in your vehicle? I mean, I'm trying to understand at what time or under what circumstances might the police officers determine that one had cash?
Yes, certainly. And this gets into 100 years, 40 years of Fourth Amendment stuff with when an officer can search a car and not, and that gets into a little bit more kind of on the search and seizure aspects. Generally, if this is an automobile stop, if the officer within, the experience and training and things like that believes that there might be something going on, they can start asking questions. If there's no other evidence other than kind of like mere suspicion, they can ask some questions, ask consent to search for the car, things like that. If they have a potentially drug sniffing dog with them, or one that can come if they have that suspicion, there's a minimal, the limited amount of time that you can actually hold someone without that sort of evidence. But if they allow for a search, or they have some other probable cause and they find something in there, or they say, oh, you have all this cash, we think that this might be, if you can't explain it, we're going to take it and go from there. In states that don't have protections for adoption, so say that Kansas, creates all these reforms where we have a higher burden of proof on this, and we do all this, but we don't do anything on adoptions. Essentially, all those protections that you're trying to put in, if a state police officer or local police officer says, well, we have this cash, we have all these different new reforms now, why don't we send it to the feds? The feds can take this if there's some nexus to a federal case, which drugs normally you will have, and they can completely do that and use their own, process. So that's a lower standard of proof, all these other things. And then local law enforcement or state law enforcement, whoever actually made the stop or took the cash or the property, gets 80% of those proceeds just for sending it over. And so that's what can kind of happen. But a general example, I would say, is that sort of thing. Someone has cash, or you're at an airport, or you're doing something like that, and really that kind of criminalization of the cash aspect can really happen. So that's why it's so critical to have these things in there, because they allow for this actual constitutional protections to occur. Without them, really, a lot of this stuff in here can be bypassed by the federal government. And frankly, I don't think that's something that America's Prosperity definitely does not want. If Kansans are voting for you all and you're passing laws, let's make sure that those things are being upheld. Yes, thank you.
Thank you, Senator Olson.
Thank you, Madam Chairman. The gentleman right here, you were talking about a police report or something, but it doesn't have to be turned in. I've learned lately, I mean, the city attorney or whoever, they don't have to look at the police report. They don't have to look at the video. It's whatever they want to do. There's nothing forcing them to look at that. I've heard of a lot of these cases where people get pulled over, and there's people that live on cash. They don't trust banks, and they cash their checks at certain places, and they get money orders when they gotta do that. But where cops have seized their money, and they're not rich people. It's a lot of times it's not a lot of money, but they've pulled them over for some traffic violation, and they had $300 sitting in their car somewhere, and they seized that. And I struggle with this one because, I mean, when someone's doing something wrong, that's a different deal. When it's a real legitimate crime, but when it's a traffic stop and they're able to go and then just seize, just like the house down in Florida or anything else, I consider the cops or whoever's taking that money to be a criminal, in my opinion, because them are law-abiding citizens that, I don't know. Maybe there's a question in there, but can you tell me more about what you were talking about your police statement? Because I heard you say something that they don't have to look at that, or
So I think the senator makes a lot of great points. The way it's currently done in some jurisdictions, when the government attorney is filing its notice of pending forfeiture, what happens is they're supposed to put in the essential facts that give rise to the forfeiture. And in some jurisdictions, what's happening is the government's attorney is saying the facts that give rise to this forfeiture can be found in a police report with either a date or just the police report number, but it doesn't set out the essential facts that would allow a judge or anybody else to see just what you're talking about. Is that cash connected to a crime, or was it a traffic stop and there just happened to be cash, and then the government seizes it and later moves to forfeit it? The senator also brings up a great point, especially in the context of $300. If an individual gets $300 seized and the government moves to forfeit it, it doesn't make sense right now for a person to go hire an attorney for $5,000 or $10,000 to try to recoup that $300. It doesn't make any sense at all. In fact, it would be insane to do that. And so,
just a couple comments. The thing I've learned on other stuff where these local prosecutors, they don't have to look at the video evidence, even if it's their own deputy or whoever, law enforcement or a stoplight or what, to validate that, which blows my mind. Why wouldn't you want to get to the truth? But two, I mean, it's just, this is just such an injustice. I think the problem is when you have the money that they're seizing go back to their own department. I think doesn't that, and most of the players are all the same players that same judges, same people do the traffic violations. Not saying there's a situation there, but I think it would be better if that seized money went somewhere else. And I think you will find, I don't know, just a better process if you just didn't have it going back to the same department.
I think the senator brings up two great points. The senator mentioned that this can be an injustice, and we certainly agree that that happens in forfeiture cases for all the reasons we've talked about. We are currently wrapping up a litigated forfeiture case where our client was not driving the vehicle. The government seized the family car, and it took nearly 8 months to get the car back. We are a free law firm, so for us, we're able to do those types of cases, but I can't imagine really any law firm or barely any law firms in Kansas that would be able to take on a case like that. So there are certainly injustices when it comes to forfeiture. I would agree with that. In terms of the money going back to the law enforcement agencies that the senator brings up, I think that there are several ways that can be dealt with. One is the money can then go to the governing body. So if it's a city law enforcement officer who seizes cash, that could go maybe into the city's general fund, and then it can be dispersed back. I think one point when it comes to money, there is data that suggests or that says that forfeiture does not solve crimes. And so I think for a lot of opponents of forfeiture, the argument is we need this money to be able to solve crimes. And I've referenced this before, and I'll do it again. There are reports from the Institute for Justice. The title of the document is Does Forfeiture Work? Evidence from the States. And according to this study, it says, my results do not support the contention that forfeiture leads to greater police effectiveness. Forfeiture's effects on clearance rates for all reported crimes were not statistically significant, suggesting additional forfeiture revenue does not translate into more crimes solved.
Thank you. Senator Haley.
Thank you, Madam Chair. This is an incredibly important issue. With the chair's permission, given the time constraints, may I hold my questions and redirect them potentially to Mr. McRoberts, and if available, Mr. Glod, after we have heard from the opponent testimony. My questions involve the threshold amount seized as well as jury trial, but I see that there's some other discussion. With the chair's permission, rather than you would go on to the next section.
Appreciate folks' attention to the time. This is a committee that's scheduled until noon, so we don't usually meet till noon. So we do have some leeway if it is a proponent question. I would ask it now.
Well, thank you, Madam Chair.
Uh,
I think some of it may come up during
in
the course of the opponents, but as well, the same thing, threshold amounts as well as jury trial. I'll constrain my questions to that, but it could be a lengthier discussion, and I do know that we have a full docket for the opponents.
We'll appreciate the considerations, Senator. Mr. Revisor, Mr. Thompson, there in the bill is no threshold amount, or is there, before you can, before the government can seize property? Is there a proposed low threshold?
Thank you, Madam Chair. Jason Thompson. No, there are no thresholds in the bill. That was an option presented to the interim committee, but that was not adopted and is not in the bill.
Does that help answer your question, Senator?
It does and it doesn't. I was going to propose to both the proponents and the opponents, some of whom were on the committee as I was, the interim committee as I was, much about that discussion, because as was just discussed, Senator from Johnson raised, sometimes it's such a small amount that's taken. And I think the testimony would show, though I don't want to speak for either proponent nor opponent, that that particular amount being so small is not worth the going through the process, retention of attorney, et cetera, to get it back. And that those are the lion's share, of the majority of that property that has been seized in Kansas and other states.
Would you like to pose a question now to proponents or not? You've kind of heard the issue and
Thank you for the indulgence. Then I think it would be better couched toward the end if we've heard, but I don't know if you would allow a redirect after we've
usually
heard
we don't have proponents come back up, which is why I was suggesting.
Well,
if you have the question.
With the chair's indulgence, if Mr. McRoberts and or Mr. Glod would at this time want to speak to the exemption of any particular threshold amounts that weren't considered in this bill, and how that might be a part of the underlying problem with recovery of these same amount, and what percentages of the seizures those compose. I appreciate it.
So Mr. Glod can follow up, but according to data from the Kansas Bureau of Investigation and a report that was done, it appears that half of all seizures have a value of $3,000 or less, and 62% of the seizures have a total value of $5,000 or less. And so the senator raises a great point, which is this does involve an incredibly low dollar amount, and it is difficult because of that to retain an attorney to try to fight to get back that money. So in terms of the threshold that was discussed at the interim committee, I think that there was some debate about what that dollar figure should be, but it's, I think, totally appropriate for this committee to consider a threshold as well.
Thank you.
Thank you. And Mr. Glad, if he is available, if you would like to opine. And thank you, Mr. McRoberts, Madam Chair.
Wow.
No, certainly. I just kind of wanted to follow up with what
Mr. Glad,
McRoberts.
can we keep it brief?
Yes, I totally agree with what Mr. McRoberts just said. I think a threshold amount could be critical. Other states have done that, particularly when it comes to either equitable sharing or just their general adoption policies, or they've limited the type of properties that can actually be forfeited. So if you only have one car, something like that, if it's your domicile, it can't be seized immediately. It could potentially be forfeited later on, but you still allow that individual to, use their car for transportation, pick up children or things like that, or at least live in the house. We have some stories of people, getting evicted without even being, arrested for a crime. And so that's difficult. So I'll pause there. Thank you.
Thank you. And I have just a few quick questions for Mr. McRoberts. We heard in the special committee, I was the vice chair of that committee, that 82% of civil asset forfeiture is initiated by a traffic stop. Is that correct?
That seems consistent with what I've heard.
Okay. And then do you have a percentage of people who simply give up and never claim their property?
According to the interim committee report, I think they set the number at 70%.
70% don't come forward to claim it. And it's correct that civil asset forfeiture, it doesn't require that a crime be charged, and it doesn't require a criminal conviction in order to for the seizing entity to retain the asset. Is that correct?
That is.
And then some of the opponent testimony mentioned that they don't have any facts related to Kansans being harmed by this process, but I think we've heard some in some of the questions from the members of the committee. And what would you say to that? That there's no court case to look up about a person being victimized by this process. I mean, is that something you would see in a court case, or can you talk about that?
Sure. I have put an example of a case involving Barbara Reese, and I believe it took her between 20 and 25 years to get money back that had been taken from her. It also required legislative action for Ms. Reese to get her money back. There are also examples within the law review articles I've talked about how difficult this is for individuals. And there are court cases where they say that this is procedurally very difficult for individuals to be able to go in without an attorney and get their property back. And I think, perhaps law enforcement hasn't heard complaints by citizens, but I wouldn't expect citizens to be complaining to the very agencies that are taking their property and taking their money. And so I think there are examples of people who have been severely and detrimentally impacted by asset forfeiture in Kansas.
Thank you. And one other quick question. Some of the testimony talks about a compromise on this issue or on this bill, or do you know anything about that?
I can say that we're always willing to talk to law enforcement. We're always willing to talk to opponents on asset forfeiture reform and try to come up with the best kind of legislation that can get passed.
Thank you. And a quick question from Senator Olson.
Sure, it's really for research. I was just wondering if we could get background on the what other states have done and if there's some cap set. So thank you.
That's a very relevant question. A lot of that information, I believe, was presented in the special committee on civil asset forfeiture. So those documents should be available that talk just about a comparison between what Kansas has and doesn't have and what other states are doing.
Thank you. I'd like to see that. I wasn't on the committee.
Sure, absolutely. And if we could make that available as a committee document to share, that would be helpful. And so those in the audience can see that as well. And with that then, committee, there is proponent written only testimony from Lucretia Nold, Kansas Catholic Conference, as well as Curie Myers, former sheriff. With that, do we have any neutral conferees? Not seeing any. Our first opponent conferee is Daniel Burrows, Chief Deputy Attorney General. Please please introduce yourself and welcome to committee.
Good morning, Madam Chair, members of the committee. I'm Dan Burrows. As the Chairwoman said, I'm the Chief Deputy Attorney General. I'm here on behalf of the Office of the Attorney General. I don't want to read my written testimony because I think it's going to take more than 3 minutes, but I encourage you to read it because I think there's a lot of important information in there. I just want to hit a few points. First off, the Attorney General supports a reform of our civil asset forfeiture laws, but what he supports is currently embodied in House Bill 2606. We think that civil asset reform is necessary because civil asset forfeiture is an important tool, but it's easily abused. And there has been near constant attention to the issue from this legislature since 2017. The time to act is now, and the bill to act upon is the one that is currently pending in the House and will receive a hearing later today. I do have to say, however, part of the difficulty of being a law enforcement agency that is in favor of civil asset forfeiture reform is holding together some sort of coalition, because the feeling from the law enforcement side oftentimes has been that the other side are not reliable negotiators, that any ground that law enforcement gives, no matter how reasonable on this issue, will be seen as weakness, that it will be if you give a mouse a cookie all over again. And frankly, that is what we have seen from the proponent testimony today. The proponents bring in a lobbyist from the District of Columbia to argue for provisions that a Kansas committee not only did not recommend, but considered and rejected. He couldn't even deign to travel to Topeka for this hearing, and he spent all his time talking about
Mr.
other
Burrows,
states and
he's
other
explained
courts.
his flight was canceled.
Fine. He spent all his time talking about other cases in other courts and not referring to anything that's a problem in Kansas. The committees that considered this in the interim did consider the issues in Kansas, and we believe have put forth a durable compromise between the proponents and the opponents. But I do worry that advancing this bill risks the fixes on which there is actually consensus, and will confirm fears from the opponents of any reform in the past, who have held this up for several years, that we're just going to be back here next year. I want to note that the Attorney General's office thinks this stuff is important, has pushed for changing the standard of proof to clear and convincing evidence. Internally, we've changed our procedures for looking at asset forfeitures that are brought by our special assistant attorneys general. We review those stringently. We've stopped several unnecessary forfeitures. No one's allowed to file anything under the authority of the attorney general without my sign off. We agree this is a problem, but we think the way to address it is the bill that everybody can agree on that is pending in the House. Thank you.
Thank you. With that, we will hear from Edward Bain, Kansas Racing and Gaming Commission. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Edward James Bain, Kansas Racing and Gaming Commission, speaking on behalf of the staff. I invite you to read my written testimony, which discusses how forfeitures are used on the gambling side and illegal gambling side. But as way of introduction, the gambling that I'm going to talk about is gambling machines that you all may see in your cities and counties at gas stations and restaurants and liquor stores, that the video electronic machines that look like slot machines. Many times those are illegal games of chance, which are only legal inside casinos. They're advertised and they're branded as games of skill, but in reality, no amount of skill can increase the prizes that are won. And so that's what I'm talking about today when we're talking about illegal gambling as it relates to forfeitures. Bottom line is current law is working to slow the spread of illegal machines in Kansas. And we see some of the proposals as being making settlement less likely, creating more litigation, or creating a situation where an agency cannot even do forfeitures to stop criminal activity. I want to touch on three parts of the bill quickly. The first is switching the clear and convincing evidence, or switching to a clear and convincing evidence from preponderance of the evidence. This proposal simply encourages the machine owner to conceal more cash or commingle cash with legitimate business cash. And by using this standard against us, there is nothing stopping them from expanding their illegal gaming operation and putting illegal machines anywhere they choose, because there's nothing stopping them if we can't forfeit their cash without them taking extra steps to conceal the cash and making it much harder to slow their expansion. The second, the attorney's fees provision, the fee acts as a penalty for losing a case. And there's a lot of lawyers in this room, and we've all lost cases where we've given a compelling closing argument, where we've had the facts fit like a puzzle, our witnesses have been engaging and credible, and we still lose. Cases strong cases are lost sometimes. And I don't think a penalty should be assessed to an agency just simply for losing a case. Penalties should be reserved for egregious misbehavior or willful misconduct, not simply for losing a case. And it could be a good case. And this really paints governments in a corner, having to decide whether to try and take a forfeiture case, even a good case, because you just don't know sometimes, and good cases are lost. And finally, the reduction in time to get a case sent to a county attorney. It really creates an inefficient and complex bouncing of the case from agency to agency in a very short manner. And I heard my time is up.
Speaking of time, yes, so sorry about that.
Thank you.
Thank you. Next, we will hear from Tony Mativi, Director, Kansas Bureau of Investigation. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Chairman Warren, Vice Chair Wilborn, Ranking Member Corson, thank you for the opportunity to testify about Senate Bill 458. Echoing some of what Mr. Burrows said, I am testifying this afternoon in favor of House Bill 2606 because that bill mirrors the recommendations that came out of the committee, and I believe applies thoughtful, measured, reasonable restrictions to Kansas asset forfeiture law that provide an additional layer of due process for the hypothetical innocent owner who has property seized. Okay, I am testifying in opposition to this bill because of the provisions that go beyond what are in the House bill, which in my view are unworkable and perhaps even counterproductive to what folks are trying to accomplish with regard to shortening the amount of time for an innocent owner to get their property back. That's the difference between the two. I want to follow up on two things that were said earlier. Mr. McRoberts is correct that the data support about a 70% number of defaults. What he did not mention is we don't know the reason for a default. He says people walk away because the system is too complex and too frustrating. That is a potential reason for the default. Another reason for the default is the person says, yes, that was my drug money and I'm not going to fight you over this, okay? Yes, I was using that car to drive dope to a sale. Yes, I was receiving drug shipments at that house and I'm not going to contest. There is no data to support how much of that 70% are frustrated innocent property owners and how many are actually drug dealers who are choosing not to contest the forfeiture. Another thing said today was Mr. Burrows talked about sometimes the folks on the law enforcement side are frustrated because we don't view the folks on the other side as truthful negotiators. And let me give you an example of that you've heard just this morning. The lobbyist from Washington, in response to one of your questions, Senator Gossage, talked about how if the government seizes your money and then you can't explain it, then it's subject to forfeiture. That is a deliberate misrepresentation of the standard. Okay. To go to your question, Senator Olson, if the government takes money, they have to show a probable cause belief that there is a connection between that money and illegal activity, usually drugs, sometimes human trafficking. Without that connection, there can be no forfeiture. So what you were told here today, Senator Gossage, was a deliberate misrepresentation of the standard by the folks on the other side of this issue. And that's one of the things that's frustrating for law enforcement. I respectfully request that when it comes time for questions, you ask the same questions to the folks on the proponent side, because I think the answers that you get will not only be more candid and more truthful, but also reflective of the fact that there are real differences of opinion here as to asset forfeiture, and that's why compromise was so important, and that's what's reflected in the House bill. Thank you, Madam Chair.
Thank you. Next, we will hear from Sheriff Jeff Easter, Sedgwick County. Please introduce yourself and welcome to committee.
Good morning, Chairwoman Warren and committee members. Appreciate the opportunity to represent Kansas Sheriff's Association today. Just a few things that I want to point out is there is no doubt in this state that we're seeing an increase in the amount of narcotics being trafficked in here, sold in here, and being used. Mainly, we're seeing an increase in youth. That's where we stand our ground on. A lot of these issues deal with the fact that the proceeds that these folks are receiving based upon these illegal sales, we have to have probable cause to seize. We can't just seize people's money for no reason at all. It was my testimony, written testimony, where we talked about victimized by illegal forfeitures. We had a proponent talking about money just being taken by Coleman employees because they got their paychecks. I will be talking to her about that to find out the actual facts, because we hear these stories all the time and they grow tremendously. And I can tell you right now, we cannot seize money without probable cause of a crime that occurred, period, paragraph. The next thing that I want to talk about is federal adoption. We've heard all the proponent testimony on that. We have several task forces across the state where law enforcement is a part of. If this part of the bill passes, that means we cannot do prosecution in federal government, because for here in the state of Kansas, we have to seek permission from a federal agency, DEA, FBI, any of those type of folks, to even present a case for adoption before it goes to the U.S. Attorney's Office. And that means the entire case, including forfeiture. If this were to pass, we would no longer be able to seek federal prosecution at that point in the state of Kansas. When we talk about forfeiture funds, it's very spelled out in state statute what we can use those funds for. And it's not for salaries. It's not for whatever we want. It's very spelled out. And the majority of those funds are used for specific reasons, such as training and equipment. I also know that we're doing a wire right now down in Sedgwick County. All the buy money being used on that, which is a fentanyl case based out of the Sonoma cartel. All that money being used for that is out of asset forfeiture. So when folks say that we don't use it for investigations, for the most part, that is untrue, because that is the way, instead of taxpayer-funded money being used for those investigations, that gives us the avenue to use that money to perpetrate our investigations and move forward with them, to hold people accountable, because these folks are not victims. They're the scourge of what we're facing in this community. And with that, I'll stand for any questions at any point. Thank you.
Thank you. Next, we will hear from Chief Daryl Atterbury, Bel Air Police Department. Please introduce yourself and welcome to committee.
Well, Madam Chair, Council, or everybody else. I represent the Kansas Association of Chiefs of Police. And I would start with one thing, and that came from Mr. McRoberts, and that was that forfeiture doesn't solve crime. No, forfeiture prevents crime. We take away the tools people have to commit more crimes. So that's a statement that doesn't really hold water. We are out here to stop crimes from being committed on our citizens. So what I want to talk today about is the forfeiture by the jury trial having to do with forfeiture. And we believe that we would like to go with the recommendations of the interim committee, and that was to not have jury trials. We believe that through the process of having to present probable cause, that should satisfy the need in the process for oversight by the court. The other thing I would like to talk about is a minor adjustment to the 1/2 aggregate and having to pay attorney's fees. We at the KACP would like that to be changed from having to pay the attorney's fees after a 51% decision of the court to may. We would like that to remain in the judge's hands. They have intimate knowledge of that case as it's proceeded through. They've heard the evidence, they've reviewed the evidence, and they should be able to make the determination whether there was bad faith on law enforcement's part to whether or not the attorney's fees are paid by the claimant or by the agency. The other thing I would like to bring to your attention is this is not just about drugs. There's a whole list of offenses, theft, commercial gambling. I saw when racing and gaming came up and started talking about machines, everybody was flipping papers like, gambling? Where's this coming from? But, that's one of the things that we're trying to prevent in the state of Kansas, illegal gambling. And asset forfeiture should still be a part of our process to keep that from happening. Unlawful possession of scanning devices, a very long list of crimes where civil asset forfeiture can be used to keep our citizens safe and to stop crime instead of solving crime. Yes, we want to solve crimes, but we also want to prevent crime from happening. And with that, I'll stand for questions.
Thank you. Next, we will hear from Chief Paul Schlifke, Wamego Police Department. Please introduce yourself and welcome to committee.
Chairwoman Warren and committee members, I'm Paul Schlifke with Wamego Police. Thank you for taking the time to listen to us. I'm representing the Kansas Peace Officers Association. We're grateful for continued opportunities to share our members' input. We believe that asset forfeiture applied correctly is a tool that allows law enforcement agencies to use proceeds from crime instead of taxpayers' dollars, not only to be proactive, but also to help enforce the law. We suggest that transparency with any type of criminal or civil hearing is important because that promotes trust between us and the public we serve. Our opposition for Senate Bill 458 is based on three things. First of all, on page 7, the prohibition prohibiting law enforcement request of federal adoption of a forfeiture. Not only are there agencies in Kansas that are on federal task force, it's very possible that a local investigation we don't know at the time may raise as we go up the ladder to where we're going to ask for it to be adopted by a federal agency. And the language in this bill would prohibit that from occurring. Also, on page 15, section 7, it allows for the claimant to demand a jury trial pursuant to KSA 60-238, and the KPOA stance is this language should not be in the bill in that section. And finally, we're opposed to ordering law enforcement to pay for attorney fees if the claimant prevails, assuming that the officer acted in good faith. And the KPOA appreciates your consideration of these suggestions.
Thank you. Appreciate that. Next, we will hear from Luther Ganini, sorry if I didn't get that right, General Counsel for the Kansas Highway Patrol. Please introduce yourself and welcome to committee.
Madam Chair, Madam Chair, members of the committee, my name's Luther Gagne. I am the General Counsel for the Kansas Highway Patrol. I appreciate the opportunity to talk with you this morning. Am I not? How about now? Okay. What I would like to talk to you about specifically is the part of this bill that contains the prohibition against federal adoption. Obviously, highway patrol, we're out on the highways, we make a lot of traffic stops. That provision is of particular concern for us. And the reason why has a lot to do with the discussions that happened in the advisory committee. There were a number of things that were recommended, a number of things that were not recommended. Many of those things on the do not recommend list involved discussions of resources and what is realistically feasible for us to accomplish here in Kansas. With this goal of leveling the field, what sorts of changes could we make to make it more fair? And what sort of things are beyond our ability, given the resources we have? Things like appointing counsel. It was pretty much the consensus of the advisory committee that there's simply a lack of resources to appoint counsel for people in forfeiture proceedings. The same is true, can be said of holding jury trials and the additional time and volume that would result to the court system. The resource concern is not just limited, though, to that side. It's also a concern for law enforcement. When it comes to federal adoption, many of these smaller communities don't have the resources to investigate these types of offenses themselves. When you are considering a case that has an interstate nexus to some type of criminal activity, investigating those offenses is complex and it's costly and it strains a lot of resources on the agency. The ability to request the federal government to do that is a beneficial ability that many law enforcement agencies have. Related to our concern with including this is just the cumulative effect of all of these changes. The fee shifting, if you add to that an increased burden of proof, you add to that a demand for a jury trial, and add to that we're not going to permit federal adoption anymore, we've gone beyond leveling the field. And we've made the system so impossibly difficult to navigate that the government won't be able to take your property. If the concern is it's too easy, we have to be mindful of making it too difficult as well. Thank you.
Thank you. Are there any other opponents in the committee room or on WebEx wishing to testify? Seeing none, then we will open it up for questions, but I'd like to procedurally clear up for the audience who may be following along online or in the committee meeting room. The report of the Special Committee on Civil Asset Forfeiture to the 2024 Kansas Legislature just came out yesterday afternoon. I was honored to serve as vice chair of that special committee, and the report's been referred to a lot, although it wasn't available at the time testimony was turned in by our conferees. And just want to point out that you can see there on page 1 of the report 8 recommendations of the special committee, and then 4 other recommendations of the committee that they be studied further by a standing committee. The committee that met and generated this report is not a standing committee of the legislature. It was a special committee. And I'm also honored to serve on the Kansas Judicial Council. And the other thing that our conferees have testified about is there was an advisory committee. There was an advisory subcommittee to the Kansas Judicial Council, and they made a report after their very hard work in that subcommittee. They offered their report to the Kansas Judicial Council. And after deliberations, the Kansas Judicial Council made no comment on the report, did not adopt the report, did not reject the report, and simply received the report as the work of the committee. So just some clarification on kind of procedurally some of the items that have been discussed today from our conferees. So thank you for that indulgence in clarifying the procedure for our audience. And with that, then we'll open it up to questions. Senator Gossage and then Senator Corson.
Thank you, Madam Chair. I would like to ask Director Mativi to come to the microphone, please. And this is why we have opponents and proponents on a particular bill, because you may hear something and then, ask a question of the opponent. We've heard a couple of times now that there is support from the opponents for House Bill 2606. Can you tell us who sponsored that bill and what it does or does not do compared to this bill as to why the support for this one, the 2606?
Sure, ma'am, I'm sorry, I don't know who sponsored it.
Okay.
The reason that I support it is that
Please go ahead and identify yourself.
Oh, I'm sorry, Tony Mativi, Director of the Kansas Bureau of Investigation. That bill, ma'am, exactly mirrors the recommendations that came out of the committee that met over the summer. I served on that committee along that. See, I haven't seen the report that the senator just referred to. I'm talking about the report that was generated after months of work this summer by folks on both sides of this issue. So law enforcement was represented, and Mr. McRoberts recounted for you very accurately that those were robust, respectful, thorough deliberations. We have two sides of this issue that at times I think are irreconcilable when it comes to some of the issues with regard to asset forfeiture. But out of that committee, there came a number of recommendations that I think everybody agreed would make the process more fair. So the three main recommendations were narrowing the list of covered offenses so that forfeiture only applies to distribution or trafficking or large organizations. It doesn't apply to simple possession or to users. Secondly, bringing the probable cause determination to the front end of the process and requiring an affidavit, much like a search warrant or an arrest warrant. And then finally, the fee shifting. All of those are reflected in House Bill 2606, along with one other consideration, and that is raising the burden from preponderance to clear and convincing. Again, something that I think, to me, the benefit of those is they are going to provide an additional layer of due process protection for the theoretical innocent property owner who has their property forfeited, but they're not going to restrict law enforcement's ability to use forfeiture as an effective tool. You had to listen to me, Senator, last year, come over here and ask you for money to fight fentanyl, and we used that to establish something called the JFIT, the Joint Fentanyl Impact Team. Right now, JFIT is pursuing a case in Kansas against a substantial drug trafficking network, and we're going after the properties that that network is using to receive shipments, to store the drugs, and then to ship them out. That's the kind of thing that forfeiture is a very effective tool that we use it every day. And that's why, from our perspective, we want the innocent property owner to have all of the protection that they need. In our view, we see very, very few of those. What we see are transnational drug organizations, cartels, sizable distribution rings, and this is a tool that we can use very effectively to go after them, and like the chief said, to prevent future crime.
And just to follow up, if I may, Madam Chair, I understand the balance when you're trying to protect the innocent, but go after the crime. And that makes perfect sense. So it seems to me like what we would want the bill to do, I haven't seen HB 2606, would be to, if somebody is innocent, to as soon as possible get these funds back to them, because obviously they needed them. And is there something in that bill that would be sure to do that?
So one of the things that causes me to oppose this bill is the jury trial request. And a thing about jury trials, and I mentioned this in my written testimony, is because the judicial system is still pretty clogged and bogged down, jury trials are scheduled out between 6 to 12 months. So if you add a jury trial, and and that's the way that you're going to go about trying to get your property back, it is necessarily going to take longer to get that property back. So when we listened to the other side and they had a concern about how quickly you get back your property, that's one of the reasons, in our view, jury trials were counterproductive to that.
Thank you, Madam Chair.
Thank you. We had Senator Corson next and then Senator Olson. But to follow up on part of Senator Gossage's question, has a question for the reviser. Could you explain for the audience, please, the difference between Senate Bill 458 and House Bill 2606? Because I believe they are the same except for some of the recommended areas of study for the special Committee on Civil Asset Forfeiture regarding federal adoptions and jury trial. But if you could clarify that, that'd be great. Thank you.
Thank you, Madam Chair. Jason Thompson again. And yes, the chair is correct. I started with the same bill draft. So House Bill 2606 is the 8 items recommended by the Civil Asset Forfeiture Special Committee that I discussed in the memo. The Senate bill draft has those exact same items. The things that are added to the Senate bill are federal adoptions, jury trials, and then the final section about reporting financial reports to different people in the legislature. So that's not a direct recommendation, but it's related to where the forfeiture proceeds are directed. So it's a similar financial sort of reporting aspect. So just those 3 things: federal adoptions, jury trials, and then the reporting piece in the final section of the bill. And I'll just note, because the senator asked, House Bill 2606 was requested by Representative Owens in the Committee on Judiciary on the House side, and I believe he just commented that he was doing it based on the recommendations of the interim committee, which he served on along with our chair.
Thank you. And I forgot to ask this during the bill brief, Mr. Thompson, but could you tell the committee the year that the Kansas Civil Asset Forfeiture Act was enacted? It hasn't been around forever, but something, I think it was the 1990s. But if you could answer that, that'd be great.
Thank you, Madam Chair. I was checking my information because I have in my head 1993, but I'm looking to my research colleagues to confirm my recollection. But the 1990s is close enough probably for now.
Thank you. And then back to questions from other senators, Senator Corson, and then Senator Olson, and then Senator Wilborn.
Thank you, Madam Chair. Thanks for being here. This is probably for Sheriff Easter or one of our chiefs. I'm not sure that this bill is the answer. I'm not sure that it isn't. But one of my concerns, just to take this to a little bit higher level, is with how these funds are used. Because I had a law enforcement agency in my neck of the woods come to me and say, you really should oppose any of the reforms because this is how we fund our K-9 unit. And so what I worry about is that this kind of sets out what can really be kind of a perverse incentive. If instead of funding these important units, and I love our K-9 units, I support them. If I were a county commissioner or a city councilor, I would support funding them. But when these things aren't funded through the normal process, and then we're reliant on funds that are seized through the forfeiture process, I do have a worry about there being kind of a perverse incentive for law enforcement because they're not getting all the funds they need through their normal budgetary and appropriations process. So if you could speak to that, that is one of my overarching kind of 30,000 foot concerns with forfeiture in general. Thank you. Thank you, Madam Chair.
Jeff Easter, representing Kansas Sheriff's Association. Understand your concerns. That's when forfeiture was first being spoken about, reform type issues. That's one of the main concerns. Is law enforcement incentivized to take people's property simply to afford things that we need or that we want? And the fact of the matter is that when we look, I argued several years ago to adopt the federal standards because Kansas had none. And at that point, those standards were put into place. I believe that in some areas, because Kansas is very diverse, in some areas, yes, there is agencies, because that's equipment that's used, that they will utilize asset forfeiture to help fund K-9 units or other types of equipment that they deem necessary to move forward their law enforcement, what they need to do in a law enforcement arena. And so those are always, I think, legitimate concerns. I think the way to go about holding folks responsible from law enforcement, we're not opposed to being transparent and these reports go to legislators. We're not opposed to that. There's a lot of stuff we're not opposed to that is introduced in this bill. If those are things that we need to discuss further because there's issues with it and what we could compromise on, I know the KSA would be willing to have those conversations.
I really appreciate that response, and thank you, Madam Chair.
Thank you. Senator Olson.
Thank you, Madam Chair. This is for Director Martivi. And I respect you a lot for what you do. I just want to say that. And I'm sure a lot of what you worked on and the other bill will probably solve my problems. But I think, we're probably talking about a small sliver of people. But you heard my comments earlier. Someone that's got $200 or $300 laying out, they get pulled over. That's taken. I mean, what's the normal process? I mean, that cop confiscates that money. Is there a report driven? How many people sign off on that? Is it just the cop? And
it would depend on the department and the number of layers of supervision. And that's one of the reasons, though, that I think probably the most significant item in both bills is bringing the probable cause determination to the front of the process and requiring judicial authorization before the forfeiture begins. There was a question earlier about what can we do to decrease the number of defaults? If there is a single thing that we can do to decrease the number of defaults because people are frustrated and walk away because the system is too difficult to navigate, I believe that's it. I believe the fact that we will now, under either of the bills, we will have a judge looking at an affidavit sworn out by a law enforcement officer, just like for a search warrant, just like for an arrest warrant, and that's what will initiate the forfeiture proceeding. I think that is the most significant development in this law, and that will, or in this bill, either bill, and that's what will provide a real measure of due process to the innocent property owner.
And I agree. I think that's great. I think there probably ought to be a couple other pieces, more people signing off, and the prosecutor on the other side should have to look at all the evidence, the video, everything. Right now, local prosecutors are not required to look at the evidence. Trust me. You could have the evidence to prove yourself innocent, and they just refuse to look at it. What are you going to do? You have to then take that to court.
Right.
And, you might face the ultimate consequence when they should at least look at the evidence. I mean, in my opinion, they're obligated. And I think once they do, their ethics will take over. But if they're not required to look at that, then, how are you going to?
Yeah, so again, I think that single requirement, because now you have to have an officer swear out a probable cause affidavit, go to the judge, have the judge review it, just like for an arrest warrant. To me, that's your extra layer of protection, Senator. That's where the rubber meets the road and provides a real substantive measure of due process here.
Okay, I think that's a good part. I think on the second part of my comments is how the money is spent. I think it would be better, this is just my personal opinion, as if we had the money come up here and then these agencies ask for grants where it's not a direct revenue stream for every dollar they get back to their department. I think going where it's needed is important. So thank you.
Thank you, Senator.
Thank you. Just a question regarding the due process. This is a question for the revisor or for the revisor. At the probable cause hearing, does the person who's had their asset taken, do they have an opportunity to be heard? Or is it just a presentation by the prosecutor to the court?
Thank you, Madam Chair. Jason Thompson again. I'm just looking specifically at the language in the statute, so I'll just tell you what the bill says, because I don't actually think it even mentions a hearing specifically. It just says that, I lost my place. You file the notice. So this is at the bottom of page 7, how you initiate forfeiture proceedings. So you file a notice of pending forfeiture.
That's
or
law enforcement would be doing the filing.
Right. So
Page
it's
7.
commenced by filing a prosecuting attorney, or a plaintiff's attorney, I think is the term in the act. So the attorney that takes the seizing agency's case and is filing it now. So that attorney, they file a notice of pending forfeiture or a judicial forfeiture action. And the bill says they would file an affidavit describing the probable cause supporting forfeiture. And then after that affidavit is filed, you only have further proceedings after a judge of the district court has determined from the affidavit that there is probable cause to believe the property is subject to forfeiture. So it doesn't say there's a hearing required. It says the judge makes a determination, and then it goes on to, talk about what happens if they don't, and when there's a notice, and how you're served, and your rights to come
So I
back.
think I'm correct then, at the probable cause hearing, there would not be an opportunity for the person whose asset was seized to be heard. And if that's not correct, we will be notified. And just one last question. I meant to follow up with Sheriff Easter from Senator Corson's question, so apologize, Sheriff. You were talking about budgets and things like that. So if budget requests were made by law enforcement agencies that were filled, would there still be a need for civil asset forfeiture to do the funding for our law enforcement?
So if you're talking about for the individual budgets of sheriffs and or police chiefs in that county, that's up to the elected commissioners and the elected council members to find that funding. I have in Sedgwick County, because I'll be honest with you, most of the forfeitures are caused by illegal narcotics. There is other things. I've seen very few of those, but it's caused by the sale of or distribution of illegal narcotics. And so they've gotten smarter on how they do their business. They don't carry near as much cash anymore. It's all cash apps and those type of things. And so I had to go to our commissioners to ask for additional funding for training. They did do that, but I will tell you, and I'm not trying to make this political whatsoever. However, they did tell me, don't ask for too much more because of the tax lid they're under. And so that has caused local governments to have problems with funding things that law enforcement needs to do their job.
And so then this is a funding mechanism for other law enforcement jobs, it sounds like.
Well, that's covered in statute that we can use. I mean, we can't use it to supplant salaries, those type of things. It's mainly for training, equipment, and to further criminal investigations that we're conducting.
Thank you. And then one last question, I promise. Thank you to committee and others for hanging in there. This is for the whole, those who were testifying in opposition. During the special committee on civil asset forfeiture, I asked the question, are there any studies? Is there any evidence that civil asset forfeiture, I think it's been mentioned by opponents that it prevents crime. So are there studies out there? There weren't any that were presented in the special committee. So I'm wondering, are there any studies that are showing evidence of civil asset forfeiture preventing crime? Because in the 30 years that we've had civil asset forfeiture, drugs have only been more prevalent and more coming across our border and into our state, and there's been more, it seems. We went from maybe, I don't know, heroin to meth to crack, and now we're at fentanyl, and it just keeps getting worse. So I'd ask anybody, is there a study that you can give us that shows this is effective in preventing crime?
I don't know, Mr. Mativi, if you have anything on that. The only thing I'd say briefly is that anytime that we do something in law enforcement that's crime prevention, it's very hard to measure. So I can give you anecdotal stories all the time of several stories of folks that
Right,
we
and there's
have.
studies about the effectiveness, is there anything that shows this is doing what we intended to be doing?
No. And
Okay, thank you.
I'll follow up with that by saying crime prevention is a very difficult thing to quantify, right?
Well, we've had testimony that says it prevents crime, so I'm just following up. Do we have studies that show that? And if the answer is no, that's okay, and we understand the anecdotes, but.
Yeah, the answer is no. And, the
Okay.
example that I'll follow up with it is when we seize from this drug trafficking organization in Kansas, the properties that they were using to receive their drugs, store their drugs, and ship their drugs from, those properties will not be used for crime again. That's the purpose of forfeiture.
Thank you. Appreciate that. And just for the audience following along online, when we talk about innocence, remember that the burden of proof is always on the government to prove guilt, not in this context, because conviction of a crime is not necessary in order to retain the seized assets. So there's been a lot of testimony about the innocent property owner and things. And when through this process, there's no conviction of a crime, it's difficult to use that term. But I want to thank all of our proponents and all of our opponents, our law enforcement who are out there keeping Kansans safe. And their hard work that they do. And again, thank the subcommittee, the advisory committee for the Kansas Judicial Council, as well as those who worked at the special interim committee. Thank you for your devoted attention today. It has been extra long. This is a topic that's been talked about a lot. And with that, then Senator Haley has a quick comment.
I do, and thank you, Madam Chair. I'm just wondering if we have a census or an audit of those amounts that have been received by agencies through civil asset forfeiture that might be provided to us, if that does exist.
I think it's in the report, and I think Legislative Post Audit has taken a look at it, and particularly some areas of concern in certain cities that are mentioned in the audit. In that report and the Legislative Post Audit Committee as well.
Thank you.
Absolutely. Senator Gossett, you had something?
It goes along with what our senator was saying, and that is there was some statement that 62% of the amounts that were taken, seized, were under $5,000. And I just wondered if that was true in Kansas or if that was just kind of a universal statement.
Thank you. And I think some of that information was presented at the special committee. I don't recall, but we can take a look at providing that information to committee. So with that, I want to thank everyone for their attention and their testimony today and the hard work of our law enforcement community out there. And with that, we are adjourned.